Okay, this will be the Thursday, February 28th meeting of the Judiciary Committee. I think we've got a quorum in here. There's 5 at least of us. Yep, I count 5. I think there's some more going to be wandering in shortly. We've got several other committees going today, which is not unusual, and I'm going to start out with our having a first the hearing continuation. I need to get Mr. Jacobs in here. I think we can do it as far as that consideration right now of any bill, but House Bill 1, which is the forfeiture bill, we have several people who have signed up. Not to be repetitive, excuse me, with people who've already spoken, but I want to get other groups who may have interest. I know from last meeting, Kelly McCutcheon with the Georgia Public Policy Foundation is here. Come up, Mr. McCutcheon. And please have a seat. Identify yourself.
Thank you, Mr. Chairman. I'm Kelly McCutcheon with the Georgia Public Policy Foundation, and I just have some very short remarks. First, we'd like to say that we absolutely support the authority of law enforcement to seize property that represents the ill-gotten gains of criminal activity. However, we also support strong property rights and believe taking property should not be easy. Most importantly, in the case of an innocent owner, we believe the state must bear the burden of proof, not the property owner. This bill shifts the burden of proof from the property owner to the state and therefore represents an appropriate balancing of individual property rights and public safety. We also believe the public deserves a full accounting of how forfeiture funds are spent, and we applaud the reporting requirements of the bill. Although we believe the bill could go further in protecting property rights, we believe this bill represents a step forward in terms of due process, accountability, and transparency.
It was brief. Any questions by any committee members of Mr. McCutcheon? If not, we're grateful for your presence today, and thank you. Next, we also have Virginia Galloway, who I know was here last Thursday. Ms. Galloway, if you'd like to come up, please, and identify yourself.
Thank you, Mr. Chairman. I'm Virginia Galloway, the State Director of Americans for Prosperity, Georgia. I'd like to thank each of you for considering this bill. We support the bill. We appreciate and support law enforcement as well, and love the job that they do. And one thing that we would agree on with them is the rule of law. We talk a lot in Americans for Prosperity in our economic freedom presentation about the rule of law and how important that is to all of our prosperity and safety. And part of that rule of law is the protection of private property rights. And so that is our concern here. We like the higher standard of proof for being able to take someone's property, because we know that people work hard to get what they have. We also are for transparency and accountability in reporting, and so I like the reporting requirements. I think that we need to make sure that our citizens know what's going on with that money, when it comes in, who it comes from, and where it goes.
Mm-hmm. All right. Well, thank you, ma'am. Any questions of Ms. Galloway? Appreciate you coming today.
Thank you.
Debbie Dooley.
Good afternoon. I'm Debbie Dooley with Atlanta Tea Party, also with the Conservative Capital Coalition, which is a group of we have about 30 groups affiliated with us. Julianne Thompson, Kay Godwin, and Pat Tippett could not be here because they are on their way out of town, so I'm here speaking on behalf of the group. One of the things I'd like to start off quoting something by Thomas Jefferson, and it's my favorite quote. And it goes, when people fear their government, there is tyranny. When government fears their people, there is liberty. I wholly and fully support law enforcement. They have a really, really tough job on their hands. I support fully them seizing the valuables and property if someone is convicted of a crime. But I do not support the fact that the burden of proof is on the property owner. I do not support the fact that they could actually take property without a conviction and My personal opinion is that's tyrannical to do that, to be able to take personal property without a conviction. I do support the reporting. We believe in private property rights. Many of us were outraged years back when Justice David Souter, with the Supreme Court, had that case that allowed government to be able to seize private property the way they did. We're standing up for private property rights, and we believe that in order for the government to take your private property, the burden of proof should be on them. I prefer a conviction, but I think this bill is a step in the right direction. And our people, we actually notified our people of this. We feel so strongly about it. We sent out an email that went out to over 200,000 households about this bill. And I urge you to support this bill. And that's it.
All right, thank you. Ms. Dooley, any questions of Ms. Dooley? Let me make one comment. You are aware this is what we call a civil forfeiture.
Yes, sir.
Which means you do not have to have the conviction as a means of going forward with a forfeiture of property. And the reason that is a way the aspects of someone being, first of all, charged with crime, but for whatever reason the crime doesn't go forward because maybe of illegal search, seizure, other evidentiary problems, so they have to drop that, but they can still proceed with a civil forfeiture of those ill-gotten gains, even though the criminal part of it cannot proceed.
And yes, sir, I understand that, but this civil proceeding, my understanding of the process is that this civil proceeding was instigated by criminal complaints. As I said, I prefer that a criminal conviction be made, but this is a step in the right direction, and I am fully supportive of this bill. I think this is a step in the right direction.
All right, anything further for questions of Ms. Dooley? Well, thank you for being with us today, Ms. Dooley. Is there anyone who has not signed up who would like to address the committee at this time before we close off any further public comments? All right, we'll go ahead and proceed at this time to stop comment. The bill is now on the breast of the committee. I'm going to turn over the remainder of the deliberation to Mr. Jacobs.
All right. Thank you, Mr. Chairman. Before I accept a motion on the bill, do you have any final comments you want to make?
I'd like, yes, if I could, as the prime sponsor of the bill, I'd like to close with several things. We've heard a lot of issues raised. I'm suggesting when the matter is in the committee's consideration, there's two areas that we can talk about, and those will be, as I heard raised, the issue of what level of proof of evidence is to be required by the prosecuting attorneys. That would, as it stands today, is a level which is a lower level, preponderance of the evidence. The bill calls for a slightly higher level, which is clear and convincing evidence. It still doesn't go to the highest level which you have with criminal matters, which is the beyond all reasonable doubt. I'll leave that to the committee's consideration. If they desire to look at a different level, we can have a discussion on that and possible amendments. The other area, I think, deals with the threshold, we call it, of the amount by which there could be what I refer to as administrative forfeiture, for lack of another term. The current day law calls for a $25,000 breaking point. The bill brings that down to $5,000. It was done on the basis of saying, you know, $5,000 to a person of little or no means may mean a great deal of money, but trying to recover that. The difference is the prosecuting attorneys can, giving notice to the individual, the individual is required to make a response, a filing, and say, no, I challenge your right to take my property, and then it would go into a court matter. One of the things we had tried to do, and I think it was important in this area, and that was to remove what I felt were some problems as far as people following exact proper procedure, because the case law that's developed over the years says if they do not follow specific statutory language as to how a challenge is to be filed and followed, they're out of court. They have no right to further proceedings, and they lose their property. I think that's a harsh way to look at it. So I've tried to not have these I gotchas built into it. We've tried to simplify it. We don't have a verified response made. An individual can file a response identifying himself, identifying how he acquired the property, the fact that he's making his claim, and that will be sufficient for the consideration of what that claim is going forward. That to me is a better and more reasonable way to do it. The amount of $5,000 to $25,000, that is something for the consideration of this committee if there's a different threshold to be made. I want to go back and talk about this, a lengthy bill, and I don't know how many people who have come in opposing have taken the personal time to read it. I started out in one of my subcommittee meetings talking about what I feel is a duty we owe as legislators, and I reference our state constitution, which has the 2 beginning paragraphs recognizing the protection of life, liberty, and property by due process, number 1, and then the protection is paramount as far as our duty of government to protect life, liberty, and property. Those are there, I think, the beginning for a very good reason, and that is we as legislators and those who are law officers all recognize we have an obligation, a sworn obligation to our office and to our Constitution to say we will do the things appropriate to protect our citizens from abuses of government. Now, do abuses happen in this area? I think yes. We heard of some. Don't pretend to bring in everybody that's potentially has a claim or concern about that. But I also feel that if one person is harmed as a result of our failure to have good laws that protect the citizens of our state and people traveling through our state, then we have failed as representatives of our government to do what is required. And I think the current law does not build in sufficient protection for that purpose. I was really surprised at some of the comments made from people testifying before our committee. I held my tongue. I'm still holding my tongue, but I think some of the spokespersons that came in here do a disjustice to the groups they represent. When they come in here condescending, expressing anger, and not really putting forth anything as far as rational reasons of what is wrong with this legislation. And that bothers me. Read the bill. If you find something that's at fault with it, tell us. The district attorney's brought some things. We have tried to address those concerns prior to this time with some subcommittee amendments, and I'm saying today the remainder of those things can and will be open for suggestion and review by the committee as a whole. I think I'm also somewhat surprised with the lack of the concern from my prosecuting attorneys that feel like we are not doing, or that we are doing something that is somehow hindering either their work or law enforcement's work in the enforcement of laws in the state. There's nothing in this bill that takes away the powers that we've delegated to law enforcement and to the prosecuting attorneys to enforce laws that we put on the books to stop people from doing crimes against property and other individuals. What we're saying here is once a crime occurs, we do not want those criminals to profit from the ill-gotten gains by their criminal conduct. You can go after it. We expect you to go after it. and you'll be backed by this General Assembly and certainly by this representative in those actions. We just want to make assurance that proper due process occurs. That is important. That is paramount in our Constitution. The other thing that concerns me is a lack of willingness to recognize that what we're doing is not open. The accountability and transparency of this current law lacks the ability to recognize that once these properties become forfeited, they are public property. And as public property, the citizens of the state have a right to know what comes in of property and how that property is being used. There are a number of us who believe that that is not currently well stated in the law. I think it was pointed out by Sheriff Sills. There may be finger pointing going on and saying, we don't have to report, they have to report. The other side say, no, we don't report, they have to report. So we tried to clarify that. And we get insulted for trying to recognize that there are things in here that do need addressing. But nobody's coming forward and saying, that's a good point. That's a good point. Let's be sure we do the right thing. And that's all we're trying to do. And I hope the message goes back to the sheriffs of the state, and the law enforcement people of the state, that that is the message I want you to get. I've also heard that somehow this may be some part of my doing to get back at the sheriffs. Nothing could be any further from the truth. I have nothing but respect for you. You bring up a comment dealing with back when there was a bill that we passed on the private process server. And yes, I'll go to my grave saying and believing the sheriffs did not do as I understood they were going to do. And that may be a difference of our opinion. But I don't carry any grudge against anybody. And certainly anybody that knows me for any length of time understands that. I'll walk away from an argument and never look back at it. So I apologize if you think I'm doing this as some form of meanness or getting back action to you. That ain't the case. But I'm hearing those stories coming back from my representatives that I serve with. That covers pretty much my feelings about the bill, Mr. Chairman. I think the document before you has had a lot of work. A lot of good people put effort into it. I think it's a fine product. Can it be made better? I certainly think it can, and I'm open to whatever the will of this committee is on those points. Thank you.
Questions or comments for the author or Representative Oliver?
I do not have a comment for improvement. I'm really seeking advice here because I see many very positive improvements in this system and respectful of all the work that has gone on. I look at it from my local politics, which is what I probably should do. Our sheriff right now in DeKalb County today is probably the most, in my judgment, probably one of the most respected countywide officers.
Yeah.
Now the last two ended their careers very badly and
Indicted, I think.
in jail. But
Yeah.
This sheriff, I trust more to spend this money than I do the other crap. Tell me again precisely how this shifts the authority to spend money.
Well, no, it doesn't shift the authority, and I want to comment, yes, I've known Sheriff Brown for many, many, many years when he first came to DeKalb County as head of the fire department, I believe. And so I've known and have highest respect for him. The authority of the law enforcement to have the responsibility for expenditure of the funds remains. The only thing we have done is give some clarity as to what areas those funds may be used for by law enforcement. And as said in committee, we've patterned the language that is used in federal forfeiture laws, so there's much the same thing. It doesn't change restrictions. It just gives clarity.
Does the county commission make the decision for distribution, or does the sheriff
Absolutely
make the
not.
decision? The sheriff continues to make the decision.
The sheriff, right, the sheriff still makes the decision on the bill. The only thing that involves forfeiture of assets with a local government will be if there is a acquisition of something like vehicles, real property. As I said, the police departments, the sheriff, they are office holders. They are not legal entities. There has to be a legal entity and actually hold the property. So title of it is like in a trust, placed in the hands and names of the local governments for the purpose of the law enforcement. And if it's disposed of by sale, those asset proceeds go to the law enforcement based upon that right. It doesn't ever get into use of common funds with the local government.
Mr. Whip.
Jill, perhaps you can help me. Where in the bill does it deal specifically with the duty to report to the Carl Vinson Center? I saw it in the last version. I'm
Yeah.
You may.
Sure.
The difference, Representative Olive, if you look at page 17 of the bill at line
Yeah. 567.
567, we actually define official law enforcement purpose means expenditures for law enforcement equipment, training expenses, and investigative expenses. Such terms shall not include payment of salaries or rewards for law enforcement personnel. Whereas in the current code, all it says is, it does say almost the same thing. It just says, may be used for any official law enforcement purpose except for the payment of salaries or rewards to law enforcement personnel at the discretion of the chief officer of the local law enforcement agency. And the difference in the drafting was to put some meaning behind those words. But it's still a sheriff.
Yeah. Right. Who's the law enforcement officer? Well, goes to the sheriff or the law. You have the distribution. Let me go back. We're at the part about the order, how it's to be divided up for the order presented to the court when there's a forfeiture. The recommendation made by the district attorney that will outline the involvement of whatever number of law enforcement agencies may be involved, and a recommendation. The reason for the hearing is if somebody disputes what is being recommended by the district attorney, then the court will have a hearing and make the ultimate determination on that.
The distribution is at line 627 on page 19.
Right.
take a look at that. I think her point is a good one. Let's finish that point, and then we can get to mine.
Yeah. Look at lines starting with 627. Property distribution shall be as follows with respect to political subdivisions. Property distributed in kind to political subdivision, task force agencies, departments, offices of political subdivision for official law enforcement purposes shall be designated in the order of distribution and shall be titled accordingly. That's what we're talking about. The title of it has to be with the local government, but it's only for those official law enforcement purposes. 2, currency distributed local law enforcement agencies or the multi-task force to be paid or credit to such agency or task force within 15 days of the day of the order of distribution. And this goes to current language. Provide, however, that such agency or task force shall not be eligible to receive more than 33 1/3% of the amount of the local funds appropriate or otherwise made available to such agency or task force for the fiscal year in which such funds are distributed. Such currency may be used for any official law enforcement purposes and shall not be used to supplement any local, state, or federal funds appropriated for staff or operations. So that is the restriction that keeps it from being used as a part of their a local government's general funds. And that's all current law, correct. And it says further was the reason, I don't have the line here, but like the real property or vehicles, if they're used by law enforcement, say the vehicles, so be it. If the vehicle is sold, the proceeds then come over to the law enforcement agency. Same thing with the real property. If there's a piece of real estate that has to be held by a local government, but is held, as say, in trust for that law enforcement agency. You want to know about what the accounting is to the.
Yeah, because there was.
Okay.
I wanted to sort of clarify that language.
Two places. First of all, within the Title 36 language, it's on page
686,
81
yeah.
of your bill. Section 3-23.
Hold on, I'm a little slow.
You're going to need to look two places in it.
That's fine.
It's down those
81.
in that section 3-23.
Okay, I'll look at
And
that.
then also, if you go to page, you see how it cross-references you back to subsection G of 1916-20?
Yes.
And that's on page 21. And more specifically, it's at line 696 to 698.
Okay, thank you.
Further questions or comments for the author? Seeing none, we'll go ahead and close off discussion on the bill. The bill is now in the hands of the committee. Is there a motion?
Move do pass.
Is there a second? There's a motion do pass that's been seconded. Now would be the appropriate time for amendments. Mr. Whip.
And I'm writing one as I write here. First off, regarding the issue that came up in the last meeting at page 21, line 696, there's apparently still ambiguity as to who should be submitting this report, and this issue is near and dear to my heart because I wrote the original bill. And since the law enforcement agency has the report, it seems to me to be rather silly to have the law enforcement agency give it to the county and then have the county shoot the PDF to the Carl Vinson Institute. It simply makes more sense to me to simply let the law enforcement agency, since they have the report, go ahead and do it directly. And so at line 696.
You might need to look back at 687.
Yeah.
Sorry, you might have to go back further if you want to make the changes you're talking about.
All right. Let me tell you what the changes, and I'm gonna have you help me clean it up. Basically, what I'm simply trying to do is, it shall be submitted by the local law enforcement agency to the Carl Vinson Institute. Is there somewhere else that I need to put that as well, Mr. Evans?
I think what we would want to do is, notice on line 687, says, every local law enforcement agency or the multi-jurisdictional task force receiving important property, et cetera, shall submit an annual report to the political subdivision and the district attorney specifying the property received and clearly identifying the use, including the specifics. The annual report shall be submitted to the political subdivision and district attorney at the time of the budget request. That's also in current law.
Yep.
No political subdivision shall accept that proposal unless it's on the form that's talked about in one. And then line 696, a copy of the annual report required by this subsection shall also be submitted to the Carl Vinson. And maybe all you need to say there is required by this shall also be submitted by every law enforcement agency and multi-jurisdictional task force.
Okay. I'll accept that as that will be my amendment. And I'll tell you right now, that was the original intent. Perhaps we weren't as clear in the original law as we should, but that was the original intent.
All right. So we have the Lindsay amendment. Is there a second on the amendment?
I'll second.
There is a second. So lines 696 through 698 would read, a copy of the annual report required by this subsection shall also be submitted by every local law enforcement agency and multi-jurisdictional task force to the Carl Vinson Institute of Government, et cetera, et cetera. Any discussion on the amendment? Seeing none, the chair calls the question on the amendment. All those in favor say aye.
Aye.
All those opposed, no. The amendment carries. Further amendments?
I also have another amendment.
Mr. Whip.
And, you know, this is an issue that went back and forth, and I respect my chairman immensely, but I do see the merit in taking a look at what type of standard of proof should be required, since it is. And so at 512, let's just go ahead and put it on the table and see what folks think. I may see if I get a second or not. Strike clear and convincing, and replace in its place preponderance of the.
Second.
All right. Motion by Majority Whip and second by Representative Evans. Is there discussion on the amendment?
Only discussion. We had this, of course, heavily reviewed with, and I'm the one that has in the task force the final and only vote about what we would do as to it. I just felt that we certainly did not want to go to the high level of criminal conduct, and we put in there the clear and convincing as a matter, also defining it, which if it's changed we may want to look at that, but the definition we felt had to be stated in here sufficiently so law enforcement, prosecuting attorneys, and the courts and the public knew what was expected. And that's on line 45 at the beginning of the bill under definitions. Clear and convincing evidence means proof that will produce in the mind of the trier of facts a firm belief or conviction as to the allegation sought to be established. It is intermediate, it being more than a mere preponderance, but not to the extent of certainty as is required for beyond a reasonable doubt. So it is the middle level.
Yes, sir.
Ms. Travis, I would imagine that's the only place in the bill that clear and convincing evidence appeared. No? In other places as well? Okay. All right.
Several times. If we change, we need to have, probably give her, the scrivener, the authority to go back in there and make the appropriate change where needed.
I would make that part of my amendment.
I know for sure it's on line 547.
547, get wrong sheet. Here we go. Yeah.
So would we be, with that scrivener's license, would we be deleting the definition as well? Okay. All right. Is that acceptable to the seconder? Yes. All right. Then we'll consider that part of the amendment. Any further discussion on the amendment? Seeing none, the chair calls the question on the second Lindsay amendment. All those in favor say aye.
Aye.
All those opposed, no.
No.
Chair is in doubt. Chair calls for a division of the House. All those in favor, raise your right hand. All those opposed. 5-5, the chair votes in the negative. The amendment fails. Any further amendments?
I would like to, let me ask the author at line 514 to see if we need to clear something up.
5 what?
At line 514.
14, okay.
Is number 2 designed to be an affirmative defense?
We had a lot of discussion because we moved this from the existing law.
Yes, sir.
And trying to, what you had before was the stated things the property owner had to establish as a way of hopefully obtaining their property back. And yes, these were now being used in the form of a affirmative defense.
Let me ask the author, to clarify that, to make sure that's clearly understood, would it be helpful to simply say at the beginning of 2 at line 514, as an affirmative defense, comma? Would that clarify?
I think it might be a good addition, but it's...
Okay. I would offer that as an amendment.
All right, can you restate the amendment?
The amendment at line 514, after the number 2, parentheses, beginning of the sentence should read, as an affirmative defense, comma.
All right. Is there a second on that amendment?
Second.
There is a second. Any discussion on the third Lindsay amendment? Seeing none, the chair calls the question on the amendment. All those in favor say aye.
Aye.
All those opposed, no. The amendment carries. Any further amendments?
Mr. Chair, I have an amendment.
Okay.
If we get the others first, go ahead.
We've got one other. Representative Evans.
Thank you, Mr. Chairman, and I certainly would defer to Mr. Chairman to go first with an amendment if you'd like to.
It's fine. You're recognized.
Okay. And I have a question to the chairman as well. Chairman Willard had mentioned in his comments that he might be open to changing the value question at line 253, and I was wondering if that was his amendment, I would certainly defer, but if not, if there was a level that might be acceptable.
You go into that. I was not going to touch on that. This is a threshold question, yeah.
I would offer an amendment at line 253, and if it appears anywhere else, corresponding amendment to strike 5,000 or less and change that to 15,000 or less.
Is there a second on the amendment? Hearing none, the amendment fails for lack of a second. Further amendments? Chairman Willard.
I have one back to where we were with the burden of proof, and that affirmative defenses. I think a clause in here might not be necessary, because you look on line 518. We say did not know and could not reasonably have known. I don't know, trying to establish even as affirmative defense, how do you establish something could not reasonably have known? I think the person knew or they didn't know. And I think the transferring this language and using and could not have reasonably known doesn't really add anything to it. I would suggest striking out and could not reasonably have known.
There's a motion and a second. Any discussion on the Willard amendment? Seeing none, the chair calls the question on the amendment. All those in favor say aye.
Aye.
All those opposed, no. The amendment carries. Further amendments? Last call. Hearing none, let Mr. Chairman Willard make any final comments he wants to make before I call the question.
Sir, I appreciate all the work that so many have provided in the preparation of the bill, the commenting on the bill, hopefully making the bill better. I think we've got a good public policy issue here that will be, I think, important for property rights in Georgia and protection of innocent individuals in Georgia who may get caught up in a forfeiture, and I'm supportive of the legislation.
All right, the chair calls the question on the amendment. That's to give a due pass recommendation to House Bill 1 by committee substitute. All those in favor say aye.
Aye.
All those opposed, no. It's the opinion of the chair that the ayes have it. The bill moves forward to the Rules Committee with a due pass recommendation.
Okay. I'll start back with the next bill we have. Was there someone had to get to a committee meeting earlier? Mr. Powell? You got the next bill anyway. So, House Bill 382, the bill entitled Act to Amend Chapter 1, Title 51 of the Code of Georgia relating to general provisions of torts. Yes, sir. Mr. Powell, get your mic number pushed. You would thank you. There you are.
Thank you, Mr. Chairman. There are a number of school boards around the state that are willing to let their facilities be used by whether it's the YMCA or the Boys and Girls Club for after-school recreation programs, for things for the community, for things for children. It's helpful in combating childhood obesity and providing recreational and after-school programs. The problem is that there have been concerns expressed by some school boards as to whether what their immunity or liability might be in the event that they do enter into these agreements or allow these uses. And so this bill is intended to provide some kind of safe harbor that in the event that they do elect to do this, that they know what their legal standing is. It doesn't require them to enter into a joint use agreement, but it does say that if they do enter into a joint use agreement, what the liability is, which effectively says if you enter into a joint use agreement, it has to provide certain things, and one of those is $1 million worth of liability coverage by the party with whom they enter into the agreement. And that if they do that, and as long as there's not willful or wanton gross negligence, that kind of thing on the part of the school board, that they have no liability. But it encourages the entering into these agreements. Since there was an issue raised in subcommittee, and it was brought to our attention by the Attorney General, who said that there's a provision in here requiring hold harmless agreements, and since this deals with both public and private entities, could be a YMCA or Boys and Girls Club, but it also could be a city or a county recreation program. There was concern that the hold harmless might be in violation of some provisions that say that the state can't enter into a hold harmless. And we discussed that. We suggested some language to address the issue, but we deferred to Ms. Travis to deal with the issue, and she has done so by defining what public entity is, which I presume then addresses the issue raised by the Attorney General.
That was my understanding in talking to the Attorney General.
Okay. And so anyway, other than that one change, this is the same bill that was presented to subcommittee, and I would be happy to answer any questions.
Okay. Question I have might start out as I look at public entity. We haven't got this limited as to this particular code section. Should that be noted? Public entity as used in this code section means.
It is at line 12, sir.
Okay, got you. Caught me. Questions of the presenter? We have no questions. I think we've had some people sign up for the bill. We have Ms. Ellen Reynolds. Please come forward, Ms. Reynolds. Happy to see you and have you with us.
Thank you, Mr. Chairman, and thank you for the opportunity to speak. We just wanted to speak briefly in favor on behalf of the Heart Association of this legislation. We're trying to work at creative ways to get kids out there, get them moving, and we know that Georgia has the second highest obesity problem with children in the nation. And so there are school board attorneys that differ in their opinions about the sovereign immunity. Some school boards say that they already have the sovereign immunity. Some school board attorneys say they don't. And so this is simply to clarify, to make it absolutely crystal clear for the school boards so that when they do, if they do want to enter into these agreements to let others use these wonderful facilities that are sitting there after hours, they'll be able to do so without putting themselves at risk of liability.
Thank you, ma'am. Any questions of Ms. Reynolds? Don't see any. Thank you. We have also Polly McKinney.
I hope I can be even faster than Ellen. I'm Polly McKinney. I'm with Voices for Georgia's Children, and we come to speak to you in support of this bill. And Ellen stole some of my thunder, but I do want to make a point that according to the Georgia Shape Initiative Plan, in 2008, Georgians spent $2.4 billion on the direct medical cost of obesity and lost productivity from disease, disability, and death. And further, obesity-related hospitalizations of children ages 2 to 19 increased 338% over the 11-year period between 1999 and 2010. So clearly, this is a bill that's really important to get kids, as Ellen said, to get kids moving for their own sake and also for the economy of our state. Thank you.
Any questions of Ms. McKinney? Let me ask just to follow up what both of you said. Having this done, there's nothing really compels a school board to do it, correct? But
right.
It's more of a mutual agreement.
Right.
Who would be some organizations that will benefit by having this relationship with the school boards?
I think a lot of after-school programs would love to have the access to the gymnasiums and the tennis courts and the ball fields. Boys and Girls Club would be a great example. A lot of local after-school programs. I know in our neighborhood we have a couple of folks who do an after-school program, and they're always trying to find space to get kids playing.
Would the schools be able to say, well, yes, you can use our facility, but we got cleanup costs, we got utility costs, we got maintenance costs? Would they be able to charge? Would they be charging? I guess is the question.
My understanding is that's between the contract between the school and the organization.
This doesn't.
No, I think this
mandate it, doesn't prohibit.
And I'll defer to the author, but my understanding is that this is simply a liability issue.
Thank you, ma'am.
Thank you.
Is there anyone else who wishes to address? Yes, sir. Mr. Clark. That issue.
Thank you, Mr. Chairman, members of the committee. Bill Clark with the Georgia Trial Lawyers Association. We've worked with the Senate sponsor for over a year on this bill, and more recently with Representative Powell, and endorsed this bill as a great way to get kids up and out. And as the previous speakers mentioned, utilizing school property that's not being utilized after school hours. We believe it appropriately balances the duties, responsibilities, and liabilities that would be attendant to children being involved in activities on playgrounds, in athletic facilities, and in various performing arts forums. So we support the bill. I'm glad to answer any questions if there are any.
Any questions? Let me follow up with one, if I might. You may have read the article in this morning's daily report by some school attorneys addressing this bill, and the question was put forth by them, well, we now have sovereign immunity, clearly, and now this bill addresses by language what really provides for the right of suit against a school board for damages arising from the use where caused by the gross negligence or willful or wanton misconduct of the school's governing authority. So I'm wondering, do you see that as a change in the law?
To be honest with you, Mr. Chairman, I really don't know if it is a change. I'm not sure how far it's qualified immunity that school systems have. I'm not sure how far that immunity goes, whether it reaches gross negligence, intentional torts, and beyond. I don't have the answer for you. Sorry.
All right. Yes, sir. Mr.
Question.
Lindsay.
Perhaps I'm not sure if you or the author might be the best person to ask. But reading this, it sounds like what we're doing is giving them good faith immunity, because good faith immunity can only be overcome by a willful misconduct. Would it be, to clarify that, would it be good to have in the bill simply at line 34? I'm asking if y'all would be favorable to this. After shall have good faith immunity and shall not be liable, yada yada.
I think my answer is that good faith immunity is sort of a colloquialism that lawyers use, but is probably not a term of art in the code, and it might further muddle what sort of immunity school systems have. I don't think it adds clarity. I think it might further muddle what immunity they have and what this bill does.
I won't offer it as an amendment. Just trying to clarify what's going on here. That's fine.
Any other questions of Mr. Clark? Thank you, sir, for
Thank you, Mr. Chairman,
stepping forward. No. Anyone else wish to address the committee? If not, we will close off public input. The bill is now in the breast of the committee. Do we have any discussion among committee members about the bill?
At the appropriate time, Mr. Chairman.
All right. I'm wondering about one thing before we get to talk about this issue of the waiver. I just don't know whether we, by this language, may have done something. And I know in other places we have recognized that a local governing body that has the immunity, for instance, and buys insurance, that they have not waived their immunity beyond what is the amount of insurance that is available for a claim. Ms. Travis, you know where I'm talking about, like in automobiles, and I think automobiles is one specific area. To clarify this issue about the sovereign immunity question, I wonder if that's perhaps something we might want to try to address in the bill. Mr. Powell?
Mr. Chairman, if I could.
Please.
As I understand that this is limited to those school boards who feel like that they need some certainty, a safe harbor, if you will. And, you know, if they avail themselves of this, then certainly it may change sovereign immunity as to these, but they want certainty, so it's from their standpoint somewhat of a safe harbor. This does not say that school boards have to do this if they allow some organization to use their facilities, and if their attorney tells them you've got sovereign immunity, you have no risk here, go ahead and do it, then I think they're free to continue doing it. But I think what this says is that if you've got some doubts, then this gives you a safe harbor as far as knowing what your liability is, provided that you follow these particular parameters, is my understanding.
And you raise a good point. You said by using this, school boards already do agreements with other institutions, and I know, I'll say in Sandy Springs, we have worked out agreements with several of the Fulton County schools to use their facilities after school hours for recreational purposes, even point of putting in, we put in the turf fields and everything for them, but it's their property when we do it. The point is, if someone uses an agreement with a school board, not thinking they're acknowledged by this document, what do we have then?
I think that's a point well taken, and if it's our intention to specifically limit it to those who want to come in within the safe harbor, that they should reference in their written agreement that is their intention to be bound by the provisions of this code section.
Okay. Right. And that might be the thing we need to add here.
I think that's a point well taken.
Under Part C. Where? B. Okay, I see what you're saying, yeah. Ah, yeah, shall. Recognize the agreement is entered under this section of the law. We've got our ACE script, we're working at it now.
If I may, Mr. Chairman, while she's working at it, can I ask a
We'll
question?
all have a few seconds of quiet meditation.
Then I'll hold off on my additional point that I was going to ask you.
Go ahead. I'm sorry.
I don't want to get in the way of.
Ask your question.
But you know, at line 33, at the beginning of that, is this the sort of thing that you're looking for in addition to existing protections under sovereign immunity? Tom, is that the sort of thing that you're looking for?
Something like that, yeah. But my thought was more in the line of the fact that there's addressed in here insurance, having a minimum $1 million insurance. That insurance is, I expect, going to name the school as well as whoever's the user, we'll call it, the other contracting party. And I just did not want to have something recognized that there's a waiver of sovereign immunity that may apply beyond the limits of that policy. That's what I was looking at. And we do that in other areas of law. So say the governing authority of a school shall not have waived its sovereign immunity beyond the amounts of any liability insurance applicable under the agreement, something along that line.
Or provided pursuant to the agreement.
Or provided pursuant to the agreement, yeah. That's all I was trying to recognize.
Yes, sir.
I didn't get all your words, I'm sorry. Can you say that again?
The governing
wishes.
authority of a school shall not have waived its sovereign immunity by entering into an agreement. And you said provided beyond.
Yeah, well, you said
under this.
beyond the extent of the insurance provided pursuant to this agreement.
Yeah. Why did you do shorthand?
Now, are you wanting this as part of B, or are you wanting this?
I think we can do that as a separate one and probably do this as under C. It could be at the end of C. The governing
authority of the school
school
shall not have
waived its sovereign immunity by entering into an agreement beyond the limits of any premises liability insurance provided under the agreement.
Pursuant.
Pursuant to the agreement. Just listen to the video. Yeah, we need instant replay, don't we? While we're doing this, I want to recognize the Honorable Judge Hamrick, who's also here again, sitting back quietly in the corner like he wants to be unobserved. Thank you, Judge. Always pleased to have you with us. You want to try that?
The governing authority of the school shall not have waived its sovereign immunity by entering into a recreational joint use agreement. Something where we've got premises liability insurance and provided pursuant. I'm so sorry. I'm
Close.
down.
You're close. You worn out already?
I am so worn out.
I don't doubt it. I don't doubt it.
That's as far as I got.
Well, she's not as worn out as you are. Let her read it. What did you get?
That's as far as I got, as far
Oh,
as she got.
is that read it slowly again, and we'll.
The governing authority of the school shall not have waived its sovereign immunity by entering into a recreational joint use agreement. And then something about premises liability insurance.
Beyond the limits of the premises liability insurance.
Provided pursuant to.
Provided pursuant to the agreement. How's that? We don't have a motion yet on the bill, but we also have Mr. Mabra is ready to speak.
Thank you, Mr. Chairman. Question, do you have to have the last part referencing the insurance? Normally, if you have they have sovereign immunity, the insurance, if they have insurance, it's just going to name the third parties, the insurance. They said, hey, they're covered. We have sovereign immunity already. And I don't know if it sort of clouds the water by saying, mention the insurance again, and then you say, well, maybe that insurance was supposed to apply to the school. That's just a thought. I just wanted to see what members of the committee have to say about that.
Usually these type of policies are going to name co-insuring parties, being the school as one of them. So that's what my concern is. They'll have that ability. I think Mr. Clark is jumping up and down to say something. Come forward, Mr. Clark.
If I may, Mr. Chairman, a third party can't waive a governmental entity's immunity. So the entity here, the Boys and Girls Club, let's use the example, if they purchase liability insurance to cover injury done to one of the kids they bring on somebody else's property, they aren't affecting the school system, and they certainly aren't affecting the school system's qualified immunity. The example that you talked about, the auto insurance, is where the governmental entity purchases liability coverage. Then, under certain circumstances, they're deemed to have waived their sovereign immunity.
My only concern is we're putting in here a waiver of sovereign immunity language when it says shall not be liable for any civil damages arising from the use of the school's facility unless it is proven by clear and convincing evidence the injuries or damages arising from such use were caused by gross negligence or willful and wanton misconduct of the school's governing authority. Today, if you sue the school because of a man trap on the property, you're not going to recover. You might be able to sue an individual who made it, but you can't sue the school. That's my point. And now we're getting into a waiver of liability. Now, if we want to strike that out, then it removes that whole question. And it might as well just be taken out, because it doesn't. All it does is cloud what is in fact existing law. If somebody goes out there and builds a man trap, we call it, and somebody falls in and hurts themselves, they can't sue the school. They can sue the individual. So my suggestion is take out from that shall not be liable down to the governing authority, and that removes any concern about it. That's where we are with the law now.
I understand your concern, Mr. Chairman. I have to tell you that I had a smile on my face when I read the article today. I thought, that's an interesting concern that they've raised. We're interested in making sure that there is liability coverage if a child is injured, if a third party is bringing the children on there. And that may be accomplished by simply striking everything from 33 down to the provided however in 37.
I think, the governing authority is appropriate to have them be required to be sure the third party provides insurance coverage. But I think it goes beyond when you start talking about this liability of the school board.
That's right. That's what I was looking at.
Yeah, they are. That's right. That's where it is. I didn't see that. That's right. Yeah. So C, require the public entity or private entity to maintain and provide proof of a minimum $1 million in liability insurance coverage effective for the duration of such agreement. Now, that's what you're asking for, right? Mm-hmm. So C is just muddling up the whole issue.
I can't disagree with that, Mr. Chairman. And that certainly addresses the concern of the school boards.
They will do it that way. Okay. Thank you. Mr. Fleming, do you have something you want to add to it?
Waived, Mr. Chairman.
Waived. And Mr. Mabry, you're all right?
I'm fine.
All right. We're through discussions. Now the chair will call for motions. Do we have a motion on House Bill 382? Move, do pass. Do we have any discussion or amendments on the motion? Amendments? You want to do that? You going to make an offer of that?
That's fine. So we're going to strike. Mr. Chairman, I move that we strike subsection C in its entirety and re-letter subsections D and E, subsections C and D.
Oh, C and D. Okay. Is there a second to the amendment motion? There's been seconded. Any discussion on the amendment? The amendment is striking paragraph C in its entirety and re-lettering the remaining two paragraphs. All in favor of the amendment signify by saying aye.
Aye.
Opposed, like sign. Any further amendments? That's probably a good idea. Yeah, we did miss that. Correct. Did you work up something there?
All I have is provide a citation that such agreement shall be governed by this code section.
Which would be number 5, right at the end of line 32.
Yeah. Right. So
okay.
So the language would be a recreational joint use agreement shall provide a citation that such agreement shall be governed by this code section.
Yep. Good. Okay. You want to make that a motion, Mr. Author?
Yes, sir.
Been moved as amendment number 2.
Second.
Mr. Clark wants to discuss it.
I don't think he does. Moved and seconded. Any discussion on the Powell amendment? All in favor signify by saying aye.
Aye.
Opposed, like sign. Thank you. Any other amendments? You have something you want to add to it, Mr. Clark?
If I may, Mr. Chairman, having stricken subsection C, one of the key phrases in C that I would like to ask the committee to consider adding at the end of line 32 would be the phrase "and applicable to its use of the facilities." In lines 30 through 32, you require them to have liability coverage, but nothing that makes it specifically applicable to the use of another's properties. And if I'm the insurance carrier, I say, you've got liability coverage, but I'm not sure we're willing to cover your choice of school over here where you put the kids at risk because of X, Y, and Z. And so if you added simply "and applicable to its use of the facilities," and Ms. Travis may want to add additional language to make that clear, that would certainly lock it down that they have to have coverage for the use of those facilities.
What about putting it right after the word coverage?
Yeah.
Applicable to its use of the facilities and effective for the duration would work great.
So right after coverage on line 31, applicable to the facility,
Applicable to its use.
to the
Its use.
The use.
Yeah, its use isn't right. We have to fix that.
The use.
The use.
Of the facility.
Of facilities, right. Thank you, Mr. Chairman.
Right. Effective for the duration of such agreement. We'll get your amendment. You go ahead, Mr. Powell. I know you got to leave.
Can I trust you?
Trust me, I'm a lawyer.
Thank you, Mr. Chairman.
All right. Who wants to make that proposed amendment as we have it for line 31? So moved by Ms. Oliver. Thank you, Ms. Oliver. And second to it? Second. All right. Any discussion on it? All in favor signify by saying aye.
Aye.
Opposed, like sign. That's the third amendment. Any further amendments? If not, the chair will call the main question, which is a committee substitute to House Bill 382 with three amendments having been made. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. All right. We're going to call up 468.
You have that.
Sure. Before we get started on that, Mr. Roger Bruce, you've got some guests here today that you'd like to acknowledge for the benefit of the committee. Please, sir, let me get your mic on, if you would.
I thank you. I have 3 students that came to be pages today, and they wanted to see how this process worked, and they stayed beyond the session, and they've come over to see how judiciary works. And one of them wants to be a lawyer. So if you'll stand up,
Well, all of them stand up.
all of them
too.
stand up. Yeah.
We don't have many.
Yeah.
Lawyers are getting a lot prettier.
Thank you.
Glad to have you with us. Yes, indeed. You're watching us make our sausage here. All right. Mr. Jacobs, you've got House Bill 468.
Right.
Go ahead
And
and present that.
do we have that amendment, Brian? Yes. Let's get that distributed. Thank you, Mr. Chairman. I bring before the committee today House Bill 468. I should preface this bill, and Representative Holcomb might be joining us sometime during the consideration of the bill, but the issue was brought to me and Representative Holcomb by a constituent who lives in an area that we both share but lives in his district. And so we put together a bill that amends the code section that deals with removal of school board members, which has just been exercised in a rather high-profile case, to address the situation that occurs when the removal process spawns a significant amount of litigation that threatens to siphon off funds that should be going into the classroom to pay attorney's fees for that litigation. Now, I want to be very clear that we're not seeking to cut off the right of a school board member to challenge, to mount a legal challenge, or to defend himself or herself. In fact, I think it's important to point out that there is an interesting case study in the right way to do this and the wrong way to do this in two cases that are currently pending. The right way to do it was done by the Sumter County Board of Education, which is that they filed significantly in advance of the State Board of Education's process a lawsuit in Fulton County Superior Court where they were able to show a likelihood of prevailing on the merits, and so got an injunction of those proceedings prior to the State Board of Education ever doing anything. In the ever exercising anything under holding a hearing and making a decision under the statute. Contrast that with the situation that is going on right now in DeKalb County, where the State Board of Education held a hearing, continued that hearing for a month, and then immediately preceding the second hearing, two lawsuits were filed, one in U.S. District Court, one in Fulton County Superior Court, that then caused a great deal of uncertainty. And frankly, we don't know today. There's not a quorum on the school board that's able to make a decision with regard to spending. It is unclear whether or not public funds are going to be spent for that particular lawsuit that's still going on in the U.S. District Court. And there's just a great deal of uncertainty surrounding the process. I think at some point it's important to draw a line and to say that beyond this point, public funds shall not be spent for a multiplicity of litigation challenging the statute when ultimately the kids and the stakeholders and the parents in that school system deserve some certainty going forward, and certainly the public has an interest in funds not being spent on a multiplicity of lawsuits and the attorney's fees and expenses of litigation that go along with that, but instead seeing those tax dollars invested in the kids in the classroom. So that's the intent behind House Bill 468. We worked on it a little bit in subcommittee. There is a very good amendment that I'm not going to present. Instead, I'll let Representative Evans present it, but I do want to say that I fully support the amendment, and that deals with what happens if a Board of Education member is removed and then follows the process through an administrative law hearing and then is reinstated. Representative Evans wanted the ability for attorney's fees to be reimbursed in that situation if the local school board saw fit to do that. So that's what her amendment does, but I'll let her present that amendment. I think it's a good amendment, and I fully support it when we get to that point. See, Representative Holcomb has joined us, and so I would ask the chairman if he'd be willing to recognize him at some point to make some comments as well.
We will. We've got some questions, I believe, by members of the committee of you. Ms. Stevenson, I'm seeing you down there.
Thank you, Mr. Chair. And to the author, I have several questions. I want to go back to the case study of Sumter County and or Warrenton, because I believe you mentioned two. There's two examples. I don't know if you meant that those two counties or others, but let's just take Sumter. Do you know how much funds, first of all, do they have insurance for their legal fees?
Well, for starters, there's an exception in without answering that question, Representative Stevenson, there is an exception in the bill.
I see line 16,
right.
But my question specifically relates to, because you said the case studies that they did it right was more about strategy, not funds that were expended in the public's money.
No, I wouldn't say it's about strategy. I would say it's about certainty and knowing that the process is streamlined and efficient, and ultimately that there will be an end to the litigation and the hemorrhaging of attorney's fees. In Sumter County's case, they went in and got an injunction prior to the State Board of Education even taking action, and everything they're doing right now fits within this proposed subsection.
Let me ask you this, is that case over?
No, that case is still pending.
And does this bill cover Sumter County?
No, because that case is still at a stage prior to the State Board of Education hearing, which has never occurred.
Okay.
In the DeKalb situation, it's occurred, it's concluded, and the governor has made his decision.
Okay, so if I'm reading lines 11 through 16, and when it says, where does it say, well, let me ask this, are you saying that this bill will retroactively apply to any decisions that were made prior to the governor's signing of this bill?
It applies to the expenditure of public funds as of the date of the governor's signature on the bill.
Okay.
From that point, moving forward.
From that point forward.
Moving forward. So if in fact the proceedings have completed and it's to another level, it won't apply to the exhaustion of administrative remedies that may have already occurred prior to the signing on this bill.
Whatever I would say, to kind of directly answer the question, whatever funds have been expended prior to the governor's signature have been expended, but there would be no further expenditure of public funds that violates this subsection after the effective date of the bill, which is upon the governor's signature.
Mr. Bruce.
This is kind of a continuation of our conversation yesterday, but
and I'm always happy to talk with you, Representative Bruce.
Okay. The first of all, my concern is that everything that's being done right now is a result of what you say is going on in DeKalb County. But this law is going to impact people in every county going forward. And the circumstances that exist now in DeKalb County may be totally different circumstances that exist in future situations. And all of these people they're being having to make these expenses because of the work that they were doing in their official capacity as elected officials. And what we're doing is, with this, as I see it, is cutting people off from protecting themselves and defending themselves before all of the legal remedies have been exhausted. That's why I was asking. You made the comment, no law, that you have to draw the line. And I agree. I'm all for stopping lawyers from making money. No problem. Okay.
Now you're speaking blasphemy.
But the reality is that where you drew the line, all of the remedies had not been exhausted. They still have opportunities to regain their reputation, and you're cutting them off from it if they don't have the financial means to do it. That's what my concern is that if you have the financial means to pay it for it yourself, then they can go for it. But if you don't, for whatever reason, then you are not allowing these people to exhaust all of the remedies to get their reputation back intact.
And again, Representative Bruce, I disagree with that on a number of fronts, and this goes back to our discussion in subcommittee. I mean, first of all, there is a more efficient way to do this, and that's to get whatever lawsuit's going to be filed in Superior Court done in advance, or in U.S. District Court for that matter, done well in advance of the State Board of Education hearing. That's the first thing. And then the second thing is, as I mentioned, the way that the statute works structurally. After the governor makes his decision, it's not a collective school board right, except for the fact that you've got a lawsuit still pending somewhere. It's not a collective school board right anymore. It comes down to a decision to reinstate by the governor, which is ostensibly referred out to an administrative law judge. But then at that point, it's an individual right of the school board member. And I would say that quite frequently in administrative hearings, people represent themselves. That's the first thing. The second thing is the way the statute is structured, in fact, they are on their own. And if they are reinstated, Representative Evans' amendment then provides for reimbursement of attorney's fees as well, so it helps rectify that situation.
We're getting into the question of the merits of the bill as opposed to questioning the author about language of the bill. And just keep us on the point. Let's talk about the bill, not whether it's meritorious or not. Mike. Ms. Stevenson, you want to follow up?
I'll withdraw my mine about I have another question that's not meritorious related, is bill related then.
Okay.
On line 12 of the bill, after code section where it starts with except all the way down to provided, can you explain to me what that really means?
What do you mean after?
Okay, the except to the extent such fees and expenses are incurred prior to and through the recommendation of the state board as provided for in subsection A of this code section.
What it means is that everything through the state board making its decision, including any litigation that would occur, okay, up until that time is reimbursable, or is, that can be, you can use public funds for that purpose. But once the state board has made its recommendation,
to the governor? That's what I'm trying to understand.
Correct.
Okay.
Which in DeKalb's case was done at the end of the hearing, but theoretically could be done sometime after the hearing. That's the moment when it gets cut off.
Okay.
Well, may I ask the next question? This is on the bill. On the however, that nothing in this subsection shall be construed to prohibit. Okay, when you said state board, so up until that point, in spite of what the governor may, because that's a recommendation, that's not a decision, right?
The state boards is a recommendation, that's
Okay.
right. That's what it says in the statute.
So then you're saying it's cut off before the governor even accepts or rejects the recommendation?
It's upon the school board the state board of education making a recommendation. That's correct.
Okay. I have other questions, but I'll let someone answer this.
Yes, ma'am. You had a question? Who was it, though? It's on the end? You did. I'm sorry. I couldn't tell which one. Beg your pardon, Judge. Please speak up.
Quite all right, sir. I got two questions, please, and one may have to go when we talk about the amendment. But in reading in Section 1, and of course the funds would be cut off, if then these members were to be sued for actions while they were still members before they got suspended by the board, but then after they suspended, somebody says, well, y'all had violated your oath of office, so forth and so on, would this also affect them for those acts?
Well, no. I mean, first of all, it
was done while they were still in office.
It's relating to the proceedings themselves, to the removal proceedings, okay? And that's in line 12 of the bill. And then also, generally speaking, in that circumstance, you do have a policy of insurance covering the board members that covers them, and that goes to the exception on lines 15 and 16.
Well, I just wanted to make sure, so that, because that could certainly happen, that somebody, they get suspended, and then this would take effect, and then lawsuits start being filed against them, And then my next question has to do with the amendment, and I don't know where to bring it up now, but I guess I'll go on and state it. You said if they're reinstated by the governor, then of course they would get their attorney's fees, reasonable fees. What if, though, that reinstatement doesn't come until after they go through the administrative law process and or superior court, and then they're reinstated?
Well, ultimately, they're reinstated by the governor in any event, okay?
Well, I understand.
Right.
They may have to go through all this long process. I guess that's
right. But either the governor is ordered by a superior court judge to reinstate them, or they're referred out the way that it works for the governor to make his decision, that he refers it out to an administrative law judge. The administrative law judge makes findings of fact and conclusions of law, and then the governor makes the removal decision. So under any set of circumstances, it is the governor making a reinstatement decision. or being ordered to. Yeah. But one way or another, it's the governor taking action.
Okay. All right. We have no further questions, and we have no one who's signed up to speak on the bill. Did you have someone you want to
Representative Holcomb might want to.
Representative Holcomb, sorry, you want to come forward? Speak on the bill?
Thank you for having me, Mr. Chairman, and I appreciate the opportunity to speak to your committee. And I agree with you that any statement that says that lawyers can't make money is blasphemy.
That's right.
I think many of you know, like many of you, I too am an attorney. I've practiced for 15 years. Started my career in the JAG Corps, where I prosecuted, among other things. Then I worked for one of the large law firms in town, who, in full disclosure, is one of the law firms which is billing the DeKalb County school system right now. And then since then, I've been a general counsel. And in my legal experience, one of the things that struck out at me is that when cost isn't an issue, it prolongs litigation, and sometimes it results in frivolous litigation. And what I think this bill does is it balances the two very important interests. And I want to say that I very much respect the views of those who oppose this bill, because I think reasonable minds can disagree about this. What we want to do is protect due process rights and give people fair and full access to a hearing. And I think this bill does that by providing legal fees through the hearing process. With respect to, if we're using the DeKalb example, they had about 18 hours of hearing before the state board. They had time in January, and then it was a 14-hour long hearing just last week or the week before. I've already forgotten when it took place. But with all that, the issue is, of course, how this impacts the overall school system. And dollars have been tight on a statewide level. They've also certainly been tight on a DeKalb County level. And some of the testimony that was heard at the hearing was that some of the textbooks had to be taped together. You also don't have, in many of the classrooms, and one of the findings of the SACS report was that the schools don't have internet access to the extent that they were promised for wireless books and everything else. And so I counted, I think, 6 or 7 lawyers just for the hearing on that Thursday, and at 14 hours and at the billable rates that they're charging, those are some serious dollars. And in many contexts, when you're trying to evaluate these various principles of due process with the costs, it's a little difficult to conceptualize what that looks like. In this case, it's not difficult at all. We know exactly how much is being charged, and that is not going towards teachers, it's not going towards textbooks, it's not going towards the facilities and improvements in the schools, all of which we very, very badly need. So I spoke with Representative Jacobs about this, and I support the bill. I also very much support the amendment. I think it makes a lot of sense in terms of further addressing the issues in terms of due process, and if there are any questions, I'd be happy to answer them.
I think you have one. I'll see first Ms. Stevens.
I'll let him go first.
Okay,
then I'll
Mr.
come
Mabry.
back, then I'll come back.
Thank you, Mr. Chairman. Representative Holcomb, thank you for joining us. Had a question. You brought up a key word, due process, and wanted to ask a question about your definition of due process. My definition of due process is going all the way. I'll give you an example. You go to court and someone's convicted of a crime. They serve a year, but they got it wrong in the trial court level. New evidence is presented. Attorney works his butt off for his client still thereafter. And due process, I think, is all the way when that conviction is overturned and he's freed. So the fight, I think, goes all the way until it can't go anymore. And I wanted to see, you said due process at the initial level. That's fine, but wanted to see if you think due process goes thereafter.
It depends on the context, and in the criminal context, I would definitely agree with you. In the context of a civil proceeding, I think one can create a different set of procedures and rules, and having somebody remain in jail who may be innocent, I think, is far different than what we're dealing with in this context, where people have an opportunity to present themselves and to provide testimony that it was false, to have a hearing in terms of that. I'll concede that it's not an easy question, and I think that it's fair for one to argue for them to go or to have legal fees covered all the way to the end, to use your term. But I also think that it's reasonable to take the position that Representative Jacobs and I have, which is that at some point you need to stop. We don't live in a time of unlimited resources, and the impact, particularly in this context, on the school system is so great that I think that you can have a situation where you don't, in fact, have somebody that has merit in terms of the appeal, but can just continue to spin the billable wheel and rack up dollar after dollar after dollar after dollar for their own purposes, not for the purposes of the school system. And that's money that's coming out of the classroom, and that concerns me.
All right, Ms. Stevenson.
Okay. Thank you to my colleague. I think my prelim to due process always fundamental fairness. I want to ask this question regarding the level at the state board where there's a hearing. Would you consider that an administrative hearing, the show cause hearing?
Yes.
Would you consider then the ability to go before the Office of the State Administrative Hearing Offices a duplicate of that show cause hearing?
I don't know that I would call it duplicative. It's a different context, but having witnessed the state board hearing, I think that was a fair process.
My question is, the state board hearing is not the same as the hearing before the State Administrative Hearing Office. Would you agree with me?
I do agree with that, yes.
And you can't even go to the appellate level to the Superior Court until you exhaust those administrative remedies, or in the alternative show where those administrative remedies are inadequate at law. Am I correct? Under Title 50.
I think that's accurate.
Well, then, the show cause hearing is like a preliminary matter. Am I correct on that?
In terms of equating the state board hearing to be a preliminary matter, or preliminary hearing, is that the question?
Yes.
I don't agree with that phrasing. I know that we could disagree in that.
Well, then, I may be wrong. So what do you equate that with? Because there is it's not what you would call an evidentiary hearing. There's no disclosure of evidence. There's no exchange as you do at administrative hearing. And you're still at the administrative level.
There was the presentation of evidence. There was the presentation of witnesses. There was the cross-examination of witnesses. There was counsel made available. So I think there were the hallmarks of a fair proceeding.
I think as a matter of law, I don't believe that's what it is called. My other question, you said you knew the hourly amount that the attorneys were charging the DeKalb County School Board. What is that?
No, I didn't say that. What I said is if you calculate it at an hourly rate, which is what I would presume that they're charging, and you have 14 hours and multiple lawyers billing for that single day, just that single day's worth of work, and of course there's been a lot more work besides that, is we're talking massive sums of money for a school system that's already in debt.
My last question, Mr. Chair. Do you have any evidence that every lawyer is billing on those billable hours and there's no pro bono included in their work?
Yes, I do know that many of the firms are charging. I'm not aware if any have canceled it, but I am aware that firms are being paid.
Okay. But you're not aware that everyone is billing at the same rate one way or the other, do you?
I am not aware offhand in terms of what the specific rates are. I am not aware of anybody right now doing it pro bono.
Yeah.
All right.
That's yes or no, and I'll let
yeah. No, that's no answer. That's fine. All right. Who is next? I don't know. Mr. Welch.
Mr. Chairman, may I make a motion to call the question?
All right. Motion's been made to call the question as far as limiting any further debate.
Yes, sir.
All right.
Second.
Motion made, seconded. That takes priority. No debate. Chair will call the question. Motion is to limit debate. All in favor signify by saying aye.
Aye.
Opposed, like sign. Chair rules the motion carries. We have any now no further input. There will be now a motion on the bill.
Do pass, Mr. Chairman.
Second.
Motion's made and a second to pass the bill. We have discussion on the motion. Okay, over here. I think we have one over here. Who is that? Was that you, Bush?
I wanted to make a motion for an amendment at the appropriate time.
Okay. You want to, I recognize her for first, then I'll come back to you. Yes. Motion, what do you have your motion, Ms. Evans?
Thank you, Mr. Chairman. To move an amendment, which should be in everyone's folder, AM 251312, which Representative Jacobs, Chairman Jacobs, did a great job of explaining earlier. We talked about this in subcommittee yesterday. The purpose of this amendment is to allow someone who goes through the process past the recommendation to the governor and is ultimately reinstated to have their attorney's fees reimbursed to them. So we recognize that if someone is removed and that's found to be wrongful, we want that person to be able to have their attorney's fees reimbursed to them. Another point, there's been a lot of talk about access to the process if you can't afford an attorney, and I'm certainly sympathetic to that. And that's another reason for this amendment, because as a practical matter, I know that when attorneys know that there is a provision to have attorney's fees awarded, they are more likely to become involved in that case, knowing that they might not get any money, but that they might. And so I think that this helps protect those board members who go through and are ultimately reinstated, and provides access to due process, more so for those who might not be able to afford it.
All right, we had a motion, explanation, second on it.
Second.
Any discussion on the proposed amendment, the safety amendment? No discussion. The chair will call the question on the amendment. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Ms. Stevenson, you wanted to speak.
I'm going to waive that.
You're going to waive it? Anybody else have anything else motion-wise? No further motions. The chair will call the main question, which is a due pass to HB 468 as a committee substitute. All in favor signify by saying aye.
Aye.
Opposed, like sign.
No.
Chair rules. The motion carries. Mr. Benton, you've been patiently waiting. House Bill 215. I'm going to take your bill next so we can hear from you. This is a bill to amend the Code of Georgia relating to Superior Court so as to change provisions relating to the filings in the clerk's office, to increase fees for certain filings, to change provision relating to office hours, and to provide for related matters. Yes, sir. Please proceed.
Thank you, Mr. Chairman. Appreciate y'all letting me come in. I feel like I followed the main show here.
We have one after the other.
just a load of fun, huh?
Hey, this bill did take longer yesterday.
Yes, it did. We had several that didn't agree with, but this bill was brought on behalf of the clerk of courts. They had asked for some changes in their being able to regulate their hours a little different, also for the fees, and also for time stamping envelopes and stuff that come into their office. And after what I didn't think was going to be a lengthy hearing, but turned out to be that way, the subcommittee made some really good recommendations to the bill.
Complaining about that?
No, sir. I said really good recommendations. It was a nice debate on the bill yesterday, and so the recommendations are underlined in your bill. That we wanted to make sure that when, especially in the large clerk offices, that when bags of mail come in, that they can just mark that bag as coming in at a certain time, and when they have time, they can go back and date stamp it and stuff instead of doing it right then. We also wanted to make sure that if they did stamp it and date it, that all the required fees and taxes were received at that time. That was in section 1 and we removed section 2, but at the end of section 1, we changed the office hours. We allowed those offices that had three or fewer employees would be allowed to have a break of some kind. We have some clerk's offices that only have one employee, and so we felt like that a break was necessary to be able to eat lunch or whatever. So that's the bill, Mr. Chairman.
All right. Does anyone have a question of the presenter? We have one over here from Mr. Fleming.
Mr. Chairman, the Clerks Association worked with you on this, and that's one of the things.
Yes, sir. They were the ones that asked me to bring. Yes.
No clerk story. Any other questions of the presenter? Thank you, Mr. Benton. We're pleased to have you with us. I don't think we had anyone sign up, did we, for 215? I don't see. There is one. Greg Allen? Mr. Allen, excuse me. Recognize Greg Allen, Clerk of the Court. Please come forward.
So, tell the subcommittee yesterday, thank you for your changes. Everything seems to be working well, and we have no issues. I'm just here to answer questions should any arise.
Good. Okay. So y'all are fully supportive of the bill.
Yes, sir.
Thank you. Anyone else wish to address the committee? If not, we will close off further public input. The bill is now in the breast of the committee. Do we have any discussion? All right, there is no further discussion on the bill. The chair will entertain a motion. Motion is due pass. Is seconded. Any discussion on the motion? Not. The chair will call the main question, which is due pass House Bill 215. All in favor signify by saying aye. Aye. Opposed, like sign. Thank you. Mr. Weldon, we'll take your bill number 434 next. I think there's several people want to speak on that, and I know they've been waiting a good while. And Mr. Kelly, I hope you don't mind holding yours for a little bit. 434 is the bill, and let me pull it up. This is a bill to amend the Code of Georgia relating to liens of mechanics and materialmen so as to provide that special liens include the amount due of interest and the included overhead, I believe. Go ahead, Mr. Weldon.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, this bill provides that when a materialman's lien, as provided in OCGA section 44-14-361, is filed with the clerk, and there's an action whether the amounts that can be liened or calculated to be included and incorporated in the lien amount that's pursued against the property, and will include the amounts that are related to or that are stated in the contract. And that's the purpose of the language in lines 40 through 47. It's in response to a case. It's 182 10th LLC versus Manhattan Construction Company, and that's it's kind of a interesting procedural history, but the court in pages 780 and 781 stated the following. We find that the items of general conditions cost described in the payment applications were not lienable because they were not labor, services, or materials which actually went into and became a part of the property. So what that means is in some of those things that they included in their payment applications included the setting up, if you're familiar with the way a work site, a large work site would work, or even not so large a work site, the general contractor or a contractor comes out and puts a building up like a modular home or a modular trailer that or modular office, really, I guess what it is. They put it up out there, and that's part of what the contract for doing the construction includes. The court said those type of costs are not included. The toilets out there for the workers to use are not part of the costs that are incurred in attaching improvements to the real property. So that's what this Court of Appeals opinion provide, that those are not costs that can be included in the amount that's liened. And there was dispute amount in the trial that there was these type of costs and others that were not included or could not be included in the cost. And accordingly, the Court of Appeals overturned a jury trial verdict. And I think this will help address that issue, so they can charge for having a toilet out there.
So what I understand is the court made a very limited, specific interpretation of the lien laws, where it talks about labor and materials and services, to not be broad enough to have it include what we'll call the overhead expenses that may be incurred by the contractor as a part of the providing of that labor, materials, and services, including their profit. Is that correct?
That's exactly right. And it's that's under this statute.
And in fact, in the past, has that been recognized through lien law, what we have as far as the broadness, I'll call it broadness, as opposed to this limiting language?
Correct.
Okay. Any questions of the presenter? We have one over here, I believe, Mr. Mabry.
Thank you, Mr. Chairman. Those toilets you're referring to, are those the porta potty that I'm thinking about? I see at game day sometimes that everybody's waiting in line to get into.
Exactly, and and the next time we had to file a lien over there at Georgia Tech or University of Georgia, about the preparations we had to make in order to construct the proper preparations for the stadium.
Okay.
On game day, we can this will help include that.
I got you. Those are needed.
No further questions of the presenter. I think we'll move on now. We'll have a couple of other people to speak on the bill. Mr. Greg Joy, if you'd like to step forward, and you can have a seat here by the mic and introduce yourself. And
thank you, Mr. Chairman, members of the
who
committee.
you represent.
I'm Greg Joy. I'm an attorney with Smith, Curry & Hancock. Representative Bruce will be glad to know I'm not being compensated for my time here. I'm here at the behest of
Norm.
Of course. At least you have a per diem. I'm here at the behest of the Georgia Associated General Contractors to answer any questions you might have from a legal nature about the bill. I was one of the members of the committee or task force that the AGC brought together with other groups to try to come up with the language for the bill. So if there's any question from a legal standpoint, I'm happy to answer it. I think Representative Weldon explained where the genesis of the bill comes from. It was a change in what I think most lawyers who deal with lien law recognize to be a change to what had been understood to be the scope of the lien law. And we're trying to make it what everyone understood it to be prior to that case.
And this comes, does it not, Mr. Joy, as a result of the fact that lien laws are contrary to common law principles, and therefore they are strictly construed.
That is correct,
put in a sentence.
That is correct, Mr. Chairman. I think most lawyers who had dealt with this understood that you, as a contractor, would have a right to be compensated for whatever work you had done subject to your contract, scope of the contract, and this decision limited it extremely narrowly to simply the materials and labor that went into the project itself, which doesn't seem to be fair to compensate contractors or subcontractors.
Yes, sir. Any questions of Mr. Joy by members of the committee? Seeing none, I appreciate your coming today and spending this time with us. We got Mr. Mark Woodall.
Thank you, Mr. Chairman.
Mr. Woodall, please come forward.
Thank you, Mr. Chairman.
Introduce yourself and who you represent.
Mark Woodall with Associated General Contractors. We're the statewide trade association that represents the commercial builders as opposed to residential builders. I really can't add anything to what Representative Weldon as presenting the bill and Mr. Joy. as presenting. It does actually include a few other items besides porta potties, things like cranes and dumpsters and the trailer, that temporary electricity, and all of my administrative soft costs. So we very much appreciate the opportunity to present this for your consideration and would ask for your favorable support.
Thank you, Mr. Woodall. I've got a couple of questions. If you just hold tight, I'll have Mr. Weldon first.
The soft cost would be included, provided in the event that the contract between the parties requires it, correct?
If it was part of the contract, correct.
Okay. And if it's not inside the contract, then it would be
Not
outside
included.
that.
Correct.
Okay.
Thank you. Next, we have Mr. Mayberg.
Thank you, Mr. Chairman. Mr. Woodall, quick question. Given the way the court rules and without having this new law come about, is there a chance that someone who is having a building constructed at the end could say, look, I'm going to refute the bill, and you file it, let's go to court and have a court sort of go through everything and sort of reduce the amount that really has to be paid, so now they have a different bargaining chip in doing the contracts? Could you talk about that a little bit?
Yes, sir. Some folks would suggest that that party would enjoy some unfair leverage in those negotiations. Thank you for the question.
All right. Thank you. Appreciate your coming in today, Mr. Woodall. I think that's all the questions. I'm going to ask Mr. Joy, if you wouldn't mind, come back. I want to ask you a question. Looking at the bill, and you were involved with the drafting of it. Let me take you to line 46. It says, such lien shall include interest on the principal amount due in accordance with applicable law. What are we talking about there as far as forms of principal that may be due under applicable law as opposed to interest that may be contractually due?
Well, the concept there is if contractually you were entitled to interest, that would fall under the first section, subsection 1, because contractually you're entitled to a lien for whatever the contract allowed. Under subsection, well, under the last sentence, line 46 and 47, the concept there was under the Manhattan case indicated that that interest may not be recoverable. It is not clear from that decision exactly what that means. All interest is not recoverable on a lien claim, or if only interest on the general condition costs that the court was disallowing. So to clarify that, and we believe the case law, at least several cases that date back to the 1980s, have indicated that interest is recoverable at a prejudgment rate for subcontractors at a 7% rate under Code Section 742, the legal rate, and for prime contractors having a direct contract under the commercial rate of 7416 up to 1.5% per month. So we're trying to make sure that the applicable law, which we believe to be those statutes dealing with the interest.
So statutory interest?
Well, we said applicable law. We believe that the applicable law would be the case law prior to the Manhattan decision, as well as the 742 interest rate for those not having a direct contract, and 7416 for those having a direct contract with the owner, general contractor.
The reason I say it leaves it open is somewhat confusing. That's
the applicable law
problem.
reference.
Yeah, it is.
That we labored on that issue for several hours, frankly, trying to figure out how best to address that.
Did Mr. Woodall do this?
I didn't want anyone to think we were getting something new, Mr. Chairman.
And we didn't believe that it was anything new. Again, we believe that the case law has historically recognized interest, and we're just addressing that one sentence from the Manhattan decision that just seemed incongruous with what we understood the law to be. And applicable law, we thought that would be understood to be what the law had been that would have been enforced prior to the Manhattan case.
It leaves it as a general term open to what one may wish to interpret it means.
I will agree that it does leave it open to some interpretation.
I could go around this table, I bet you I get a different opinion for every one of it.
14 or how many ever decisions,
That's right.
interpretations there are. We recognize that is a possibility.
Mm-hmm. All right, sir. Thank you.
Thank you.
Thank you, Mr. Joy. Anyone else wish to speak to the committee? I'm going to have to leave. I'm going to turn this over to you to finish up, if you will. I've got to go present a bill of my own at a committee meeting, and I'm going to turn the chair to Mr. Jacobs. Thank you.
What do we have left after this one? That's it. Okay, fine.
I have a suggestion.
Does anyone else want to speak on House Bill 434? Seeing none, we'll go ahead and close off discussion on the bill. Before I take a, well, actually, I'll go ahead and take a motion on the bill. Is there a second? There's a motion and a second. Before I recognize anyone for amendments, I wanted to see if Ms. Travis has a suggestion on the applicable law language on lines 46 and 47.
I would say can't we get rid of applicable law and cite the code sections? So in accordance with code section 7-4-2 or 7-4-16. And I'm not sure if that should be an or an and. But applicable law is pretty vague.
Mr. Joy, your thoughts?
Well, as I indicated previously, I believe that that's what the concept is, that it would apply to either 742 or 7416, the legal rate, or the commercial rate. I'm not sure if the word, I think or is the preferable word to and, because otherwise it could be arguably duplicative, and there are different rates. I presume that the courts, in looking at that, would interpret that the rate for those that don't have a direct contract would be 742, the legal rate of 7%, and those that did have a direct contract could be subject to the commercial rate of 7416.
All right.
Otherwise, you're going to have to add a lot of other words to specifically spell that out.
Okay. Ms. Travis, do you want to give us the exact wording of the amendment, and then we'll get a motion and a second on it?
Well, if I'm following what Mr. Joy just said, then and so as to avoid undesignated text, which I also don't like, if it sounds like 742 follows with paragraph 1 and 7416 follows with paragraph 2. So after purchase order on line 42, and shall include interest on the principal amount due in accordance with code section 7-4-2, and then repeat that language after real estate on 45, and shall include interest on the principal amount due in accordance with 7-4-16. Would that work?
I don't think, I'm sorry.
I'm asking.
I don't think that will work because you're dealing with subcontracts under subsection 1, and subcontracts would not be direct contracts with the owner that the lien is subject to. That's why we made it a separate sentence. We struggled with that as well when we were trying to draft this, and decided it was cleaner to have it as a separate sentence. We could be wrong. We were trying to make it as simple as we could.
Let me ask you this would make sense. If you on line 40, if we said shall include and we put interest on the principal amount due in accordance with those two code sections, could we move that language up to line 40?
Shall include each special lien specified in subsection A.
And shall include. So I'm trying to get rid of what we call undesignated text, lines 46 and 47. But I'm hyper-technical, so.
Well, would it make more sense to make that a 3?
Would it be that sentence? Would that be applicable to paragraphs 1 and 2?
That sentence is applicable to 1 and 2. You are correct.
Could we make it a D? The lien provided in this code section shall include.
I think that would make sense. copy of the language.
Could we say each special lien specified in subsection A, this is a new subsection D, each special lien specified in subsection A of this code section shall also include interest on the principal amount due in accordance with Code Section 7-4-2 or Code Section 7-4-16?
I think that's where I was going to go. Copy what was in the beginning of C.
All right. Does someone want to make that as an amendment? Is there a second? There's a motion and a second. So the amendment would be to strike lines, the language on lines 46 and 47, and replace that with a new subsection D that would say each special lien specified in subsection A of this code section shall also include interest on the principal amount due in accordance with Code Section 7-4-2 or Code Section 7-4-16, period. That's the amendment. Any questions on the amendment? Seeing none, the chair calls the question on the amendment. All those in favor say aye. All those opposed, no. The amendment carries. Any further amendments? Seeing none, the chair calls the question on the bill, and that's to give a due pass recommendation to House Bill 434 by committee substitute. You didn't make it out unscathed, Chairman Weldon. All those in favor say aye. Aye. All those opposed, no. Bill moves forward to the Rules Committee with a due pass recommendation. Thank you, Mr. Chairman. All right, we've got one bill left on the agenda. And that is House Bill 289. I'll recognize Representative Kelly to present the bill. Representative Kelly.
Mr. Chairman, if it's a committee, I'd just present from here. Ladies and gentlemen of the committee, I come before you today with HB 289, which looks to preserve consumer protection under the Electronic Funds Transfer Act, while also giving financial institutions the legal certainty needed when processing wire transfers. A little background on this bill. When the Uniform Commercial Code and the Electronic Funds Transfer Act were written, they were written to be mutually exclusive of each other, with the UCC governing commercial business transfers and the Electronic Funds Transfer Act governing consumer transactions. However, with the passage of Dodd-Frank, the Electronic Funds Transfer Act was amended to create a new remittance transfer regime, which now covers interactions between the consumer and their remittance transfer provider for consumer-initiated international wire transfers. Because of this interaction, several obligations of various parties are now undefined. This uncertainty, this will lead to legal uncertainty for a class of transactions currently governed by Article 4A, unless we do amend Section 4A-108. Specifically, this uncertainty includes that there would be no statutory rules for remittance transfers that may involve mistaken addresses or payees, as well as duties of intermediaries and other issues beyond the initial sending of the transfer. This is a change that is recommended by the permanent editorial board for the Uniform Commercial Code. They're encouraging all states to pass a law similar to this. 4 states, Arkansas, Ohio, New York, and California, have already adopted similar language, and 26 states plus Georgia have legislation that is pending. I'll be glad to answer any questions at this time, Mr. Chairman.
Any questions for Representative Kelly? Representative Welch.
Representative Kelly, do you know if this bill will adversely affect the electronic transfer of funds from the state for our immense salary to be deposited in our individual bank accounts?
I don't believe so. Your salary should be secure.
I certainly hope
Representative
not.
Welch.
An explanation of Dodd-Frank now.
Judge Caldwell, you're recognized for a question, Judge Caldwell.
That might be one you need to hold on until we get to the I'm picking at him.
I'll be glad to get that to you, Judge.
Sounds like a very good question.
And I'll hold comment for the appropriate time.
All right. Any further questions for Representative Kelly? Seeing none, thank you for presenting the bill. I've got Kirby Thompson signed up to speak on the bill.
Mr. Chairman, I just want to thank the hard work of Representative Kelly. This is an important update to Georgia's Uniform Commercial Code, and we urge your favorable support and be glad to answer any questions if needed.
All right. Any questions for Mr. Thompson? Seeing none, I'll
I have a question, Mr. Chairman.
Yes.
So I'll be prepared. Mr. Thompson, can you give me the full explanation of the Dodd-Frank legislation?
Representative Kelly, that's over 2,000 pages, and we'll have to get you a memo on that.
I look forward to seeing it.
All right. Any further discussion on the bill? Does anyone else want to speak on the bill? Seeing none, we'll go ahead and close off discussion on the bill. Is there a the bill is now in the hands of the committee. Is there a motion? There's a motion and a second. Any amendments or any discussion? Any amendments or any discussion? Seeing none, the chair calls the question on the bill. That's to give a due pass recommendation to. Where, you take my copy? What was the bill number again? 289. All right. That's to give a due pass recommendation to. Is it by committee? Yes. All right. It's to give a due pass recommendation to House Bill 289 by committee substitute. All those in favor say aye. All those opposed, no. The bill moves forward to the Rules Committee with a due pass recommendation. Get ready, Representative Kelly. There being nothing more to come before this committee, this meeting's adjourned.